All right, future barristers, welcome. We're about to tackle a piece of legislation you absolutely need to nail for your bar exams. Section 20 of the Federal Court of Australia Act. Let's make sure you walk away with a crystal clear framework for it.
Okay, let's get right into it. The entire point of Section 20 is to answer one really fundamental question. When a case lands in the federal court's original jurisdiction, who actually hears it? Is it a single judge, or do you need the whole bench, a full court? Trust me, getting this right is absolutely non-negotiable.
So here's our game plan. First, we'll lay the foundation of jurisdiction. Then we'll hit the default rule, the single judge. After that, we'll dive into the big exceptions for when a full court sits. Then we'll look at those tricky procedural applications. And finally, a judge's ancillary powers. It's a classic rule, exceptions, and application framework, perfect for remembering under exam pressure.
Okay, first things first. Before we can even talk about the specifics of Section 20, we've got to lock down the foundational principle. Let's talk about the big one, jurisdiction. And here's the thing you can never ever forget. Jurisdiction is not optional. It's not something the parties can just agree on. The court must have it, and it is the absolute first duty of any judge to make sure they do before taking a single step further. Right, with that foundation solid, let's get to the very heart of Section 20. What is the default setting? What's the starting point for any problem question you'll ever face on this topic? And just a quick but crucial clarification, we are talking exclusively about the court's original jurisdiction here. So cases being heard for the very first time. We are not talking about appeals. So here it is, the general rule, the starting point for almost everything. The original jurisdiction of the federal court is exercised by a single judge. That's your default, that's your home base. Unless you can find a specific exception that applies, the answer is always a single judge. And where do you find this bedrock rule? Section 20, subsection 1. Burn that into your memory. Section 20, sub 1. That is your anchor. Okay, so we've got the rule locked down. Now for the fun part. Let's look at the exceptions, the specific situations where a case gets kicked upstairs to a full court. So you can see the split pretty clearly here, right? On one side, you have your default rule in Section 20, sub 1, and on the other, you have the exceptions that will trigger a full court. So let's dig into those two big ones, Section 20, subsection 1A, and Section 20, subsection 2.
All right, exception number 1, this one is all about discretion. The Chief Justice can look at a case and decide, you know what, this is a big deal. This is of sufficient importance. And if they do, they can direct it to be heard by a full court. We're talking about cases that might set a major new precedent or involve some really thorny point of law. Oh, and a quick but important note, this doesn't apply to indictable primary proceedings, and that's laid out in subsection 1B. So that discretionary power, the one for cases of sufficient importance, that's Section 20, subsection 1A. Again, that's Section 20, sub 1A.
Now for the second exception. And this one is a total game changer because it is not discretionary. It is mandatory. The rule is simple. If a case comes up from a tribunal and the person who constituted that tribunal was also a judge, then the Act says it shall be heard by a full court. No ifs, ands, or buts. It's automatic.
So, the key takeaway? A tribunal headed by a judge equals a mandatory full court hearing. Simple as that. And that rule lives in Section 20, subsection 2. Write it down, Section 20, sub 2. All right, so that covers the main event. Who hears the actual case? But what about all the little procedural battles that happen along the way? You know, applications for leave, for extensions of time, all that pregame stuff. Now, this is where it gets a little tricky, and it's a classic exam trap, so listen up. You might have a case that's destined for the full court, but certain procedural steps along the way actually default back to a single judge. It's like a rule within the exception. The big show might be in the main tent, but these preliminary acts often happen in a side tent. And this is all governed by Section 20, subsection 3. It gives us a specific list of these procedural applications that go to a single judge. We're talking about things like asking for leave to even start the proceedings, begging for an extension of time, amending your grounds, or trying to hit pause on a tribunal's decision. All of that back to a single judge by default. So you can see the flow here, right? Someone files one of these applications. The default, it goes to a single judge. But there are a couple of ways it can get to the full court. First, the single judge can look at it and decide to refer it up.
Or second, if the main case is already before a full court, that court can just say, yep, we'll handle this one too. Okay, last major piece of this puzzle. Let's talk about ancillary powers. These are basically the judge's toolkit for managing the case, the practical, day-to-day stuff that keeps the wheels of justice turning. And Section 20, subsection 5, lays out these tools. Now, what's important here is that these powers are available to either a single judge or a full court. It's all about giving the court the flexibility it needs to manage its own docket efficiently. So, what's in this toolkit from Section 20, sub 5? Well, it's the real nuts and bolts of case management. Stuff like joining or kicking out a party, making those crucial interlocutory orders, rubber stamping consent orders to end the whole thing, and importantly, the power to dismiss a case if someone's just dragging their feet or if they're ignoring the court's directions. It's all about keeping things moving forward.
And here's where you'll see a really clear pattern emerge. Just like we saw with those other procedural applications, Section 20, subsection 5A sets up the exact same default rule. If you make an application for one of these case management powers, where does it go? You guessed it, a single judge by default. Unless, of course, a judge directs it to the full court. See how these subsections mirror each other? It's a really logical structure once you see it.
This quote from former Chief Justice Gleeson really hits the nail on the head. It tells you why all these procedural rules exist. He says judges do not have to devote unlimited time to listening to unmeritorious arguments. And that's the whole point. The court's time is a precious, finite resource. These rules give judges the power to cut through the noise and run their courtrooms efficiently and fairly.
So let's tie this all together. The framework is what you need to remember for your exams. You start with the default rule, single judge, Section 20, sub 1. Then you have your two big exceptions, the Chief Justice's discretion for important matters in sub 1A and the mandatory full court for tribunal matters in sub 2. And finally, you have the procedural carve-outs in subsections 3 and 5A, which send things back to a single judge by default. If you can walk through that structure, you have mastered Section 20. Now the question is, how are you going to use that in your next argument?